This Honorable Supreme Court of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court. Please be seated.
Good morning. Welcome to this session of the Tennessee Supreme Court here in Watkins Auditorium at the University of Tennessee, Martin. Our Scales Project brings together judges, attorneys, and students to develop a better understanding of the judicial branch of government and the role of the courts in our society. Unlike the cases you see on TV, today, you're going to hear real cases with real lawyers representing real clients and real judges deciding the issues. We appreciate your participation, and we hope that you will enjoy the case you hear today. I want to thank UT Martin and Chancellor Yancey Freeman, as well as the staff here at the university for hosting and helping coordinate this event. Special thanks to Judge Jeff Parham of the 27th Judicial District, as well as the additional stakeholders who have worked really hard to make this event possible. To the volunteer judges and attorneys, our appreciation for your willingness to work closely with the students in preparation for today, and to the participating schools. We thank the administration, the teachers, and the students for your participation. We would also like to recognize the Weakley County Sheriff's Office, the Martin Police Department, and the UT Martin Police Department, who are all assisting with security today. Thank you as well to the attorneys who are arguing their cases today. We appreciate the extra effort and time required for their participation. I will tell you that one of our justices, Justice Sarah Campbell, has sat where you are and taken the difficult questions from the students afterwards. So that gives us an even more keen appreciation for what you're doing today. Because we hope to support your civics education with these cases, let's frame this just a moment about the function of the judicial branch of government. As you know, your government has three branches: an executive branch, which in Tennessee is the governor, and a legislative branch, Tennessee's legislature, and a judicial branch, that's us judges. The executive and legislative branches are more political and make broad policy decisions that affect lots of people. Judges aren't political, they're neutral, and they decide individual disputes between citizens. The aim of the judicial branch is to find the truth, apply the law fairly, and do justice. Here in the United States, our courts use what's called the adversary system to figure out the truth and find a just outcome. That means both sides, with the help of lawyers like the ones you'll see today, present their view of the facts and law to a neutral party, like a judge or a jury. There are lots of rules, and the aim of those rules is to get at the truth in a fair way. Once both sides have an opportunity to be heard, the neutral party decides what the true facts are and applies the law to decide the case. If someone's unhappy with what happened at the trial court level, they can appeal to a panel of neutral judges, like the ones before you today. The purpose of all of this is to help people peaceably coexist. If we didn't have a court system, folks with disputes would resolve them by engaging in self-help, and that'd get ugly pretty fast. But if citizens have confidence in their court system, They'll bring their dispute to the courts and accept judges' decisions even when they lose, because they know at least they have been treated fairly. That's what the rule of law is all about. We hope all of you will stay engaged with the judicial branch after court today. You can follow us on Twitter at TNCourts, on our website, tncourts.gov, and on Facebook. The opinions we write in today's cases will be posted on our website and to our Twitter feed. Now, I want to introduce you to the justices of the Tennessee Supreme Court. I'll introduce them according to their length of service. First is Justice Jeff Bivens, to my right. He is a past Chief Justice of the Court. He's a graduate of East Tennessee State University with a major in political science and a graduate of Vanderbilt University School of Law. He practiced law in Nashville. He served as Assistant Commissioner and General Counsel of the Tennessee Department of Personnel and has served as a trial court judge and a judge on the Court of Criminal Appeals. He's been a justice on this court since 2014, and he lives in Franklin. Justice Roger Page, to my left, is also a past Chief Justice of the court. He's a graduate of the University of Tennessee Health Sciences Center and the University of Memphis College of Law. He practiced law for 14 years before being elected as a trial judge. He was appointed to the Court of Criminal Appeals in 2011 and the Supreme Court in 2016. Justice Page lives in Henderson. Justice Sarah Campbell earned her undergraduate degree from the University of Tennessee at Knoxville and a master's degree from Duke University and at the same time her Juris Doctorate from the Duke University School of Law. She served as law clerk to Judge William Pryor on the Federal Appellate Court and to Justice Samuel Alito on the United States Supreme Court. Before her appointment to the Tennessee Supreme Court in 2022, she was Associate Solicitor General and Special Assistant to the Attorney General in the Tennessee Attorney General's office. Justice Campbell lives in Nashville. And Justice Dwight Tarwater was confirmed as the newest justice on the court just this year. He earned his undergraduate degree and his law degree from the University of Tennessee at Knoxville. As a trial lawyer, he handled hundreds of cases and appeals, both federal and state courts, and was recognized as one of the premier trial lawyers in the United States. He served as general counsel to former Governor Bill Haslam for 6 years. Justice Tarwater lives in Knoxville. I'm Chief Justice Holly Kirby. I graduated from the University of Memphis with a degree in mechanical engineering and from the University of Memphis School of Law. I clerked for a federal appellate judge, Judge Harry Welford, and then practiced law in Memphis. I served on Tennessee's Court of Appeals for 19 years before being appointed to the Tennessee Supreme Court in 2014. I live in Memphis. So, as you can see, we come from different parts of Tennessee, and we all have different backgrounds. We all consider it a great privilege to serve on the highest court of our state, and we are committed to applying the law fairly, protecting individual rights, and upholding the Constitution. Now, we're ready to get to work. Our excellent appellate court clerk, Jim Hivner, will now call our first case.
Robert L. Trentham versus Mid-America Apartments, LP et al.
Chief Justice Kirby, may it please the court, Robert Parsley with Miller Martin for the appellants, Mid-America Apartments. I'm here with my co-counsel, Jenna Adamson of Bradley. Would the court like me to begin with a short statement of the facts for the benefit of our students, or are they already familiar with
Are you
them?
reserving any time for a rebuttal?
Yes, 7 minutes.
Okay. Yes, for the benefit of the students, very, very quick. We've obviously read your briefs and understand everything, but I think that would be helpful.
Just briefly, this is a slip and fall case. Mr. Trentham lived in an apartment complex, was crossing a pedestrian bridge that had a wooden surface. It had rained. He slipped and was injured and felt a clear, slick substance at the spot where he fell. And the question is, should Mid-America Apartments have known about that condition and corrected it before that event? Thank you. There's two key points that I'd like to make today. And the first is that under the facts of this case, the court should conclude that constructive notice is not properly established under Blair. That holding would help clarify Blair that mere foreseeability is not enough, that there has to be a past history of actual events to put an owner or possessor of property on constructive notice. Second question is Blair itself. How effective of a precedent is Blair? How effective and workable is its rule for establishing constructive notice and therefore a duty, right? Ultimately what we're here to talk about is, did Mid-America have a duty to correct this situation?
Mr. Parsley, are you asking us to overrule Blair?
Partially, I think so.
How so?
What's that?
How so, sir?
Well, I think some of its language is difficult to apply, like the phrase general condition, okay? Let me illustrate that. You know, the premises liability duty is an affirmative duty. It's not merely avoiding negligent conduct. It's taking some affirmative act to remedy a situation. To have constructive knowledge of that, it requires very specific kind of foreseeability, right? You need to know the specific condition that you're there to correct. How do you correct a general condition?
Well,
How do you know about a general condition?
You started out talking about the specific facts of this case, and the trial court made credibility findings. The court found the plaintiff very credible and also gave great weight to the testimony of the corporate representative about the pressure washing once a year that should have been done and wasn't done, et cetera. How does that equate with everything else you're trying to tell us?
There's no credibility finding that's relevant to the issues in this appeal. The only credibility finding that the court made, actually, the trial court made, is that Mr. England, who is the service manager, had said in his deposition that he was unaware that the property had been pressure washed, and at trial he said, well, I've now learned that it was, and the court noted that out. That's the legitimately reading the trial court's opinion, that's the only credibility determination that was made.
Well, what about the fact that he said that he believed the plaintiff when the plaintiff said that he fell and couldn't get up? There was a slimy substance on
the fact that a plaintiff is believable doesn't mean the defendant is not believable, right? An affirmative credibility finding without comparing that testimony with someone else's testimony about the same fact it doesn't somehow make it a better finding, right? No one else, there's no evidence from anyone other than Mr. Trentham about what was on the bridge.
Mr. Parsley,
Yes.
I'd like to ask you about, eventually this will get to, I guess, what our standard of review here is.
Yes.
You know, we have said in a couple of cases that this requirement of actual or constructive notice of the condition is a requirement in addition to the elements, traditional elements of a negligence claim. You know, in your brief, you seem to characterize this knowledge requirement as really part of establishing that the defendant had a duty, owed a duty to the plaintiff.
Yes, Your Honor.
And I just like you to elaborate that on a little bit. Do you think we've been incorrect as describing it as an additional requirement? And then let me just ask one more question that you can kind of answer in responding to all of that. And that is, how does the characterization of this requirement, if at all, affect our standard of review? The existence of a duty, we have said, is a question of law. But constructive knowledge or constructive notice, we have, or at least the Court of Appeals has characterized as a question of fact for the jury. So what is our standard of review here in light of all of that?
To your first question, I think it's incorrect to characterize the premises liability elements as in addition to the elements of negligence. There's a district court opinion by Eli Richardson, Judge Eli Richardson, here in the Middle District, that makes precisely that point. It wasn't cited in the briefs, but I could bring it to the court's attention. The point is that the premises liability requirements really dovetail with standard negligence requirements. It's not like you have standard negligence requirements and then tack these on in addition. They affect the establishment of a duty in the first place. You do that by establishing actual or constructive knowledge. So establishing constructive knowledge is part and parcel of establishing a duty, right? I think that's the correct understanding of it. And that's a question of law and the court's review of that, of determining whether constructive knowledge exists, should be reviewed de novo.
Including the question of whether constructive knowledge exists, in your view, is something we review de novo.
Absolutely.
Mr. Parsley.
And I think that's consistent with the cases that we cite in the brief.
Mr. Parsley, in your opening remarks, you alluded to this and clearly briefed. It seems that you're advocating for a standard that, in essence, would put us in the premises liability area much as in the same category as we do in the dog bite rule. It's the one bite rule. It seems to be you seem to be advocating a one fall rule here. Is that what you are telling us what needs to happen for constructive notice?
Well, it's different, right? When you have general negligence, someone's liable because it was foreseeable that their conduct could cause harm. In premises liability, to establish constructive notice, right, you have to have facts that occur to put you on notice, right? That's what Blair requires, a past history. So, excuse me. So when the appellee characterizes it, well, it's one free pass, that's adding a value judgment.
Is it? I mean, if we're saying that the first person who falls is never going to recover,
that's not our position. Our position is if there may be instances where a condition itself without an accident can put someone on notice. Right. But the mere fact that an accident occurs doesn't mean an owner necessarily was on constructive notice of it. If that's the case, then it's strict liability.
Mr.
Right?
Parsley, let me ask you this. I tried several of these slip and fall cases as a trial judge. Where does the fact scenario fall in your analysis when in a busy grocery store, water is allowed to be on the floor for an hour and a half and nobody does anything about it and somebody comes along and slips and falls in it? How would you analyze that fact scenario?
Well, the first thing you would look at is, can the plaintiff establish how long the water was on the floor, right? Well, first there would be the question of, is there actual notice of the owner, right? Does the owner actually know of it, or did it create it, right? So an employee put the water there, okay, knowingly. If that can't be established, then you can establish constructive knowledge based on showing that that water had been there long enough that the owner should have discovered it and remedied it. So if it's been there for 10 seconds, that's probably not long enough. If it's been there for 10 hours, that's probably long enough, depending on the circumstances.
How does this work with the standard as articulated in the third restatement, where basically in the premises liability situations, every premises owner has a duty of reasonable care, and that can change depending on whether it's a condition that he or she created, it's a condition that a third party created, or it's a natural condition where the what constitutes reasonable care is just a fact issue for regular people with their knowledge of their lives to assess. How does that,
Well, that
how does
sounds,
that factor in?
yes, Your Honor, that sounds more like discussion of the standard of care, right? What should a person have done once the duty was
But
established?
basically, in that scenario, everybody has a duty of reasonable care.
Right?
So the foreseeability doesn't go into the assessment necessarily of duty. It always remains a fact issue for the jury. How does that factor into what you are arguing?
I want to make sure I understand the court's question because the third restatement wasn't in the briefs. What you're saying is that premises liability owners just are given a general duty to keep premises safe? I'm
A
not
duty
sure.
of reasonable care, which can depend on the origin of the condition and the general, I mean, much of this is so fact-specific. As you are trying to articulate in response to Justice Bivens' question, and I had the same question, are you basically saying a one-fall rule?
No.
And you're saying no, and then you're couching a whole lot of facts. I'm not sure whether what you are arguing is really clarifying the question of constructive notice, or whether it is simply narrowing the circumstances that premises owners will be liable.
Okay, let me answer that. Thank you, Your Honor. Let's look at Blair, right? Under Blair, in premises liability, there's kind of a predicate duty to the duty to correct a condition or warn about a condition. You have to know about, or you should have known about. This case is should have known about. Inspection is key to that, right? This court has said repeatedly, knew about or should have known about with due diligence. What that means is, did you reasonably inspect the property? And here, well, and so that falls into the question of constructive knowledge, okay? And so if it's determined that adequate, a reasonable person standard, reasonable under the circumstances inspection was done, but a hazard wasn't discovered despite that, there should be no constructive knowledge. So there is some consideration of the facts underlying that, but it's still ultimately a question of law, which establishing a duty is a question of law.
Mr. Parsley, you cite in your brief the McClung decision, which was a case involving liability for the criminal acts of a third party, store owner's liability. And what I find interesting about that is that that case really seems to allow the imposition of liability in perhaps a broader set of circumstances than in certainly than I think the standard that you're advocating for would allow. You know, there we said it's not necessary to have a past, a specific crime that had occurred on that property. We allowed the duty element to be established by even evidence showing, general patterns of crime in the area. How do you reconcile the standard that you are advocating for here with what we said in McClung?
Good question, Your Honor. First, there is a distinction when you're talking about third-party conduct versus just an inert condition. I think there are somewhat some special rules for addressing protection against third-party criminal conduct. McClung required exactly what we're advocating for, is that there needs to be a past history to put an owner on notice. McClung, in that case, there were 164 prior instances of crime on or near this parking lot within the past year.
Those crimes were, they weren't all, I think only one of them maybe was a kidnapping crime or something even,
That's right.
even, remotely similar to the crime that actually occurred in that case, which was kidnapping and murder. Most of them were things like theft and,
That's right.
So
But
Yeah, elaborate on how that's actually consistent with your position here.
Well, I think in our position, I think that third-party crime is different because an owner can't control third-party conduct, okay? You can be aware of it, but you can't control it, whereas you can control conditions on your property.
But you can't control things like natural forces, right?
No, but you can
Weather
respond to
conditions.
them. But I think there's a key distinction between that and the criminal context. What we're advocating for, I just want to make our position clear. What we're saying is Blair tells us about the kind of things we need to be concerned about if we're going to establish constructive knowledge based on past events, right? Patterns of conduct, continuing conditions, recurring incidents, i.e. recurring accidents. But it doesn't give us guidance on how to go about making that comparison. And that's where John Gerber provides help, because John Gerber was all about establishing constructive knowledge of a dangerous condition and the dangerousness of it and its progeny. It shows how to go about doing that comparison, and I think the comparison is substantial similarity. So in the criminal context, that's what McClung talks about. It talks about similarity, proximity, things of that nature. So I think you could say if it's a financial crime, well, how's that relevant to someone being, right, a fraud, securities fraud, that's right. But if it's a violent crime, I think violent crime of many kinds can still be considered substantially similar to a current crime.
So how does that, if you're not advocating for something like the one bite rule for dogs, then how does that help you? Because your client was aware that if you've got a designated walk area that's made of something natural like wood, we all know that wood or brick or things like that, you get slime on it. And your client apparently actually did know that and said, we need to watch for that.
I would respond, I think that's factually incorrect, Your Honor.
Okay, please correct
Okay.
me.
The key to the appellee's position is this maintenance policy that says we pressure wash. Okay. Preventative maintenance, we pressure wash once a year, or as needed based on what? Inspection. We discover there's a problem. There is no evidence of algae ever having occurred before on the bridge. There's no evidence of any complaint about algae ever having occurred on the bridge. The maintenance policy said nothing about algae, was not targeted toward algae.
Well, what's the point of having a policy of pressure washing? They're not doing that for the appearance of the bridge.
Sure, excuse me, I don't mean
in
to interrupt.
the
Your Honor.
context of the testimony, was like, we like to spruce up these bridges and make them look nice, so we pressure wash them?
The maintenance policy was not specific to the bridge. It had to do with the common areas of the property, and it was cleanliness. We keep it clean by pressure washing it once a year, and safety. Like if we notice there's a problem and there's something sticky, we can pressure wash it
Right,
away.
that's
But you
fair.
have to know it's there first. There's the only evidence in the record about algae comes from the appellee's expert, hired after the litigation began, and says, well, you had this policy, therefore you should have known that algae can grow. Well, how do you know algae is going to grow on that bridge? Algae requires time, moisture, water, sunlight kills it. There's no evidence to establish that there was sufficient wet and shady conditions for long enough for algae to grow here. The only evidence in this record of algae is the expert's opinion that, well, it could grow, and it assumes that's what it is, and then says, well, in America you had a maintenance policy, and that could have washed away algae, so you have knowledge. Well, that applies to any problem that could be pressure washed away. I'm sorry, if you have a maintenance policy, you're now on constructive notice of anything that maintenance policy could possibly correct. And that's really strict liability, right? You're saying you have to know in advance everything you need to correct and prevent it from ever happening. And that's just not what Tennessee premises liability laws ever required. It's far too great a burden on owners. Yes,
I'm
Your
sorry,
Honor.
I didn't
No,
mean to
that's fine,
interrupt
that's
you, Mr.
fine.
Parsley. But your argument raises what seems to be an interesting question, and that is, what is the level of knowledge required, or the level of notice required? There was admittedly this policy to pressure wash the bridge, right? And the bridge was not pressure washed for a couple of years,
it was a
right?
policy to pressure wash the common areas, not specific to the bridge.
Well, I'm just looking at the testimony of your client. What is the standard of care applicable to that bridge? We make sure that it's pressure washed frequently,
Yeah.
at least once a year. And if there's a need that arises, it's more often than not. So let me ask my question, okay? Is a general knowledge of a condition sufficient to create a duty on the part of the property owner? Or does it have to be specific? Are you actually saying that, oh yes, the property owner had to absolutely know that algae could have grown on the bridge, otherwise there's no liability?
Could have grown, right? A general maintenance policy doesn't put the owner on notice of a specific hazard that needs to be corrected. And knowledge or constructive knowledge, actual or constructive, of a specific hazard is what's required to impose an affirmative duty for an owner to go out and correct something. How can you correct something if it doesn't exist yet? It's foreseeable.
So
That's saying that they must just keep their property clean 100% all the time, and that's strict liability.
So in this case, if the property owner doesn't follow its own procedure, and let's say another accident occurs, let's say there was ice on the bridge, or there was mud on the bridge, or something like that, and you have a property owner not following its own procedures to pressure wash the bridge, then the way I understand your argument is there's no duty on the owner in that standpoint, because they didn't know the specific thing that might occur.
My time is out, but I presume the court would like me to answer
If
the
a
question.
justice is asking you questions, you certainly can answer.
General versus specific, Mr.
Yes. A policy, the maintenance policy, is designed to make a property safer, in part. Okay? The premises liability duty arises when an owner knows or should have known about a specific condition that it could correct. If you have a maintenance policy and then you're going to create a duty because you have a maintenance policy, owners aren't going to have maintenance policies anymore. Right? That's contrary to public policy.
Okay.
How's that positive? Thank you.
Thank you.
May it please the court, counsel, students, teachers, good morning. My name is David Fine. With my partners Charles Malone and Jason Callan, we represent Robert Trentham, the plaintiff appellee in this case. And of course, we ask that the court affirm the judgments below. This case requires the court to determine what constitutes constructive notice for purposes of premises liability under Tennessee law, and to announce a rule of law that is fair, clear, and workable for this and other cases. MAA's brief and its argument this morning do little to assist the court in doing that, because they keep shifting what they say the rule ought to be. In their opening brief, they espoused a rule that would say only duration and prior accidents, which amounts to the dog bite situation that Justice Bivens referred to when my colleague across the aisle was standing before the court. In their reply brief, they back off a little from that. In the oral argument, they never actually articulate a rule for the court. And that's, of course, what the court needs to do, and then to apply it to Mr. Trentham's case. We are, of course, prepared to do that. There is no need for the court to overrule Blair. Blair is a proper statement of what the law ought to be. It could perhaps use some additional explanation. And I am prepared this morning to give you our view of what the rule ought to be.
Mr. Fine, if I could interrupt you there, I'm curious how you think the facts of this case satisfy the standard that was articulated in Blair. Can you tell us which language in Blair, which category of Blair the facts of this case fall into?
I'm pleased to do that, Your Honor. Blair, of course, referred to the premises owner having knowledge of a pattern of conduct, a recurring incident, or a general or continuing condition. In this case, we would contend that there was a general or recurring condition, principally a general condition. And the rule that we would ask the court to espouse is simply to give some additional context to the Blair test by simply saying that the landowner, the premises owner, must have knowledge of one of those things that is superior to that of someone who might come on the property. So and of course, superior knowledge is the basis for Tennessee's allowance of premises liability when the premises owner did not, in fact, create the problem in the first place.
I'm sorry.
No, please go ahead, Your Honor.
What is, if you could just be precise about what is the general condition that the evidence in this case establishes the defendant had either actual or constructive knowledge of?
Absolutely. As I think it was Justice Tarwater was reading from the interrogatories and from the deposition testimony, MAA knew that for safety purposes, it had to pressure wash the bridge at least once a year or more frequently if need be. It also knew that it had not done that. In both regards, its knowledge was superior to that of the average person who would come on the property, like my client, Mr. Trentham.
So the general condition is that it had bridges bridges or other areas that needed to be pressure washed on a regular basis. Are you saying that is the general condition that existed that imposes a duty on the defendant?
I think, I'm sorry, Your Honor, I didn't
Go
mean to
ahead.
interrupt. It needs to go further than that. The general condition is that to maintain the safety of the bridge, it had to be pressure washed. And as the Chief Justice noted, common sense tells us that the reason that you're trying to maintain safety on the bridge by pressure washing is because you're concerned about foreign substances and the danger they might pose.
So but wouldn't that impose a duty then related to anything that any substance or any hazard that it could occur on a common area in the apartment complex that could have been corrected by regular pressure washing?
No, Your Honor, because under the test as we propose it, which imposes that knowledge requirement and that it be superior knowledge, under those circumstances, the property owner has greater knowledge of a particular safety concern, the potential for danger.
But so let me just make sure I understand your position. So your position is not that the general condition is the algae growth. It's not that narrow, am I right?
That's right, Your Honor.
It's the general condition of having bridges or other areas that need regular pressure washing to ensure their safety.
That's right.
I mean, that strikes me as potentially imposing sweeping liability if we go that route, if we say that sort of general condition is sufficient to establish constructive knowledge.
Well, but please recall, Your Honor, that the rule as we articulate it, or as we would ask the court to articulate it, more importantly, is one that requires that there be knowledge of that. So it's not simply that there's some general notion or general foreseeability. My friend across the aisle says in briefing, and his amici say as well, that we're asking the court simply to say, well, if it's foreseeable, then there can be imposition of liability, there can be constructive knowledge. And of course, we're not saying that.
Can I ask you about one piece that keeps bothering me, and there may be some proof that I'm not aware of.
Yes, ma'am.
So please forgive me if it does. But the testimony was that from MAA that there should be pressure washing of the bridge once a year, or, you know, if something comes up, if it is specifically needed. And that was what the trial judge hung his hat on. How do we, what proof is there in the record that if MAA had adhered to that policy and they washed the bridge 364 days before your client fell on it, I mean, where is the proof that if they had adhered to that standard that they articulated, that it would have helped your client?
Your Honor, I'd offer two responses to that. The first is that Dr. Dethridge, who was Mr. Trentham's liability expert, testified, I think, consistently with the idea that there was causation, which is, I think, what your question goes to. The other thing, just for procedural purposes, is that MAA has never questioned that point. It didn't in its briefing before the Court of Appeals, or for that matter, in its application to this court, or in its merits briefing to this court. So, and the trial court, of course, made a finding of proximate causation.
But how does, I understand that the trial court made a finding, but it has to be based on evidence. Is it Dr. Dethridge?
It is, Your Honor.
What did he say that indicated, for example, that MAA, if they'd been following their policy, they would have washed this bridge a week before this gentleman traversed over it? I mean, how do we know that there is actual?
Your Honor, I'll be candid. I don't recall the specific testimony, but I do recall that Dr. Dethridge addressed that matter and that the trial court found causation and that it hasn't been challenged. So I apologize that it's not a more fulsome answer for you.
Okay.
And
I talked to, go right here just a second.
following up with that, let me ask you the same question I asked Mr. Parsley. What credibility determinations here were made by the trial court, and how do those impact the decision you're asking us to make?
I think really only in one principal respect, Your Honor, and that is that Mr. Trentham testified that there was something slimy, and Dr. Dethridge testified that given the conditions and given the science, that it was almost assuredly algae or fungus or some sort of organic growth. And of course, the trial judge credited those determinations. And so those would go, I presume, to causation or something along those lines. So those were, I think, credibility determinations. And I will take just a moment because I think it's important to correct something that Mr. Parsley said when he was up in his argument in chief. And that is that there was no evidence that the pressure washing was a policy. It wasn't a policy of theirs. It was simply something that they did. There wasn't a written policy. They didn't even articulate it as a verbal policy. It was just something that they knew as a matter of best practices that they needed to do, and they didn't do it. And I'm sorry, Justice Tarwater, did you have something?
Yes, and it's a follow-up to what Justice Campbell and Chief Justice Kirby asked you. I want to make sure I got this right, okay?
Yes, sir.
There was not a whiff of evidence of algae until your expert issued his report in this case. Am I right?
I don't think so, Your Honor. Putting a particular label on it, perhaps, but of course, the moment Mr. Trentham had the accident, within days, he had written to MAA's management and said, and this is in the record, and he had said there was something that wasn't water, that was slimy, that was, I don't think he used the word viscous, but something along those lines. So that wasn't something that sort of came up later from Dr. Dethridge. He simply said, yes, the science corroborates that. This is what it would be. So yes, there is that evidence.
Okay, so your client says the bridge was slimy, and your expert then said the source of the slime is algae.
Yes, sir.
And then he went on to, did Dr. Dethridge then make that link that Chief Justice Kirby was asking you about?
I believe he did, Your Honor, yes.
That because of the growth of algae and because the bridge was not pressure washed, that created the dangerous condition, right?
Yes.
Okay. Now, if it's the algae that's the cause of the slime, and the algae is first known after your expert, which I assume you compensated for his time in giving his opinion in this case.
I would presume that it was not pro bono.
And he says, okay, it's algae. So how is that constructive notice to the property owner?
It's constructive notice because what the property owner knew by its own admissions was that to maintain the safety of that bridge, it had to pressure wash the bridge. And it had to do it at least once a year or more frequently than that. And it didn't do it, which is, of course, the breach of the duty. But the constructive notice was that it had superior knowledge that it needed to pressure wash the bridge to render it safe, and that they hadn't done that.
All right, so final question. Mr. Trentham, your client,
Yes, sir.
he saw the bridge, right? He knew where he was walking,
He did.
and he saw the same thing that the employees of the property owner saw, correct?
I would presume so. But of course, what he didn't know was that it hadn't been pressure washed. And if I might, consider an analogy. I mean, I don't know that there would be as many concerns about the scenario and about constructive knowledge if, for example, there had been a swimming pool on the property, and the property owner knows that to render the pool safe, you need to use chlorine or whatever chemical is the appropriate substitute for chlorine, and it knows that it hasn't done that. And by the end of the swim season, any number of residents have fallen ill because of various growths. We would say, well, of course you knew that. You knew that you had to do something to render it safe. Well, this is analogous to that situation.
How does
Now-
this not, I mean, the defendant in this case makes the point in its briefing that, imposing liability or imposing a duty in these circumstances would essentially penalize property owners that, have these sorts of maintenance policies. And that point is persuasive in my view. I think, let me ask it this way. If you take out the evidence here that the testimony by Mid-America's corporate representative that, they had this practice, we'll not use the word policy given that there seems to be a dispute about that, but they at least have this practice of pressure washing the common areas, on a regular basis. If you take that evidence, is there a duty here?
If you take out the evidence that they knew
That they had a regular practice of pressure washing. Take that out of the case.
I-
So all
I-
you have is
probably
expert
not.
testimony. All you have then is expert testimony that, algae can grow in these circumstances which existed on the property. Maybe you have evidence that, they knew that these circumstances existed, but there's no evidence that they have a practice of pressure washing.
I will agree
You would
with Your Honor
concede that there would not be. So liability, or at least imposition of a duty in this case, is really hanging on the fact that Mid-America had this practice.
I will agree with you, Your Honor.
And how does that not end up disincentivizing property owners to establish those sorts of practices?
Your Honor, that's an argument that you hear frequently from defendants in cases like this. Well, don't penalize us for doing this. And I think the answer is that common sense tells us that it is always in the enlightened self-interest of property owners like MAA to prevent the accidents in the first place. If I were counseling them, and I often do, by the way, because I often represent defendants, what I would say to them is, my goodness, don't hang your hat on the idea that you can avoid proof of notice after the accident occurs. Prevent the accident in the first place. And I think that's what most folks do, especially when they've got insurance companies giving them advice. It didn't happen here, but there's no reason to think that there would be disincentivizing if this occurred in this case. It's an interesting argument, but I think it's belied by the common sense of knowing that it is always your better practice, both business-wise and to be in a position to defend yourself in a lawsuit, to be able to show that you did everything you could, not to say, well, we didn't have any policies, so you can't hang notice on us.
So what did Dr. Dethridge testify about about how long algae takes to form on a surface like this. I paged through the trial court order, didn't see anything specific on this particular hole that's bugging me. And so did he testify that it could take a year to grow? And so if they had pressure washed it,
I don't believe,
less than a day, less than a year ago, it would have prevented this?
I don't believe he testified that it would take that long. I think he said that it was a shorter period of time than that.
Well, okay, you do have to have some testimony about the standard of care.
Correct.
And the standard of care here, apparently the trial court took property owner's policy. We should wash these areas, pressure wash them once a year. That's the standard of care. He credited testimony to the effect that they did not do that. I don't know how, if they had adhered to the standard. The whole point of negligence is if you had adhered to this standard of care, this wouldn't have happened. And I'm just not sure that I have seen evidence that closes that loop.
And Your Honor, I gave you the best answer I think I have for that, which
All
is
right,
that
well,
he
obviously we'll just have
established.
to look at Deathridge's
And I
testimony.
apologize that I can't give you any more detailed
that's okay.
explanation for that.
Is your position about, I guess, your characterization of the general condition in this case, giving rise to a duty, limited to cases involving like naturally occurring conditions like this that would take some time to occur? I mean, suppose instead of having algae growth, we had, someone who was carrying dish soap across the bridge, spilled it, it went everywhere. We all know that's incredibly slippery. People use it to make slip and slide, so it's all, it's everywhere. And someone, comes across the bridge sometime thereafter and falls. Would you be able to rely on the same general condition to impose a duty in that situation?
It's not the same general condition, certainly, Your Honor, but if the property owner knew that people were taking the substance and it was spilling, which is essentially Blair, right? Blair is engine fluids leaking out at the mall. And in that scenario, if there is knowledge by the premises owner that is superior to that of John Smith, who walks onto the property, that there might be a danger from that, then that is constructive notice. In the language of Blair, it said that if there is information in the possession of the premises owner about any of that series of types of occurrences or events that Blair talks about.
Right, but here you seem to be saying that what is enough for constructive knowledge is that they had this policy of pressure washing, not that they knew anything about the possibility of algae growing.
No, I'm not saying that. I'm not saying that, Your Honor, because they didn't just have a policy of pressure washing.
Well, pressure washing to ensure safety. That's
right, and that's the critical point. If they had a policy that said, well, we do certain things to address the aesthetics of the bridge, we paint it once a year, something like that, well, obviously that wouldn't do it. But the knowledge, I won't call it a policy because, frankly, even if it were a policy, it wouldn't matter because its relevance here is that it shows knowledge on the part of the property owner, knowledge that the safety of the bridge requires pressure washing.
So would that be enough then? So if you have that test, you have testimony similar to what you have here, that we have a practice of pressure washing to ensure the safety of the common areas, plus expert testimony that dish soap, dish detergent is slippery and can cause falls. Would that be enough to establish a duty in that situation?
It might. It might. It would depend upon things like the schedule for pressure washing and things like that. So, and let me turn to another point that MAA has offered up, and that is the notion that the rule that we espouse would somehow render premises owners insurers of the safety of their premises. And you hear this from their amici as well. And of course, that's not the case because it's limited. Two of the principal bases, first principles, if you will, of premises liability law in Tennessee as elsewhere, are that we impose liability on premises owners, even if they didn't create the unsafe condition, because they're deemed to have superior knowledge. That's why, of what's going on the property. And that's why we regard them as potential defendants. And the other is that we don't want them to be insurers. Well, the rule that we would ask the court to espouse, and I'm happy to read it for the court, would limit those occurrences to ones that give the premises owner that superior knowledge. If there weren't that superior knowledge, there would be no liability. And let me give the court an example. The court's decision in Parker, the hotel shower bench case from 2014. Parker was a case in which the bench was built. There was apparently some defect, but it was behind the wall of the shower. And when the fella sat on it, it gave way and fell. But there was no evidence that the premises owner knew of anything that might give foreseeability to that occurring. And the court declined to find liability. That's the limit. If you focus on, did they have knowledge of these things that was superior to others? And if I might, Your Honors, this is the rule that we would ask the court to adopt. And it is, as you'll gather, very similar to Blair, but with just a little gloss on it to give additional explanation. The premises owner must have knowledge superior to that of others who might come on the premises of a pattern of conduct, a recurring incident, or a general or continuing condition that should make it foreseeable to the premises owner that there is a dangerous condition on the premises. That's Blair, but with the overlay of that superior knowledge, which gives additional context to the Blair test. My opponent argues in his briefs that Blair is hopelessly confusing. Now, mind you, he focuses on the part of the Blair test that's not at issue in this case, which is prior accidents. And nobody has contended in this case that there was a prior accident. So there's a great deal in the briefs about a situation that simply isn't at issue here. But Blair isn't terribly confusing. If it needs to be tweaked a little, we would submit that that's the way to do it, to put that gloss on it about the superior knowledge, which is consistent with Tennessee law on premises liability. Now,
let me ask you a question about the superior knowledge part, and we'll get back to the question I asked you earlier. Who has superior knowledge? The person who is walking across the bridge at the time of the fall, or the property owner who may or may not have been available at that particular time? It seems to me that superior knowledge is knowledge at the time of the incident.
well, it may be, Your Honor, but the answer is the same in either event because the condition was not visible to the naked eye. Mr. Trentham could not see that, nor could somebody from MAA. But what MAA's folks did know was that to maintain the safety of the bridge, they had to pressure wash it, and they knew that they hadn't pressure washed it. And Mr. Trentham didn't know that. So at whatever point you're measuring superior knowledge, at the moment Mr. Trentham first stepped foot on the bridge, the superior knowledge was still MAA's superior knowledge. And as I say, I'm trying to articulate a test that I think will both give breadth to the range of factual circumstances in which premises liability cases can occur. Because as I think the Chief Justice noted when Mr. Parsley was at the lectern, there are any number of circumstances in which it can arise. Blair was understanding that. It was trying to broaden things a little bit.
So you are saying that that would go to the general condition component in Blair, that it has to be a general condition of which the property owner had superior knowledge?
I think it would go to anything, Your Honor. You know, any of those categories that Blair lays out. Because it helps to give definition to those. Because the basis, of course, if you're asking about constructive knowledge, it means that you've already decided that the premises owner did not create the problem and did not have actual knowledge of the problem. So we're to constructive knowledge. And there, it is absolutely reasonable that there had to be some information in the possession of the premises owner. And that information would make it reasonably foreseeable to that premises owner that there was a dangerous condition. And it had to be knowledge superior to that of the average person who comes upon the property. Your Honors, I'd like to just briefly touch on our negligence per se argument. But I don't want to switch topics if the court has any other questions on the premises liability issue.
Go for it.
All right, thank you, Your Honor. The negligence per se issue, I think, is very simply understood this way. The trial court said, I disagree with you on negligence per se, but I agree with you on premises liability. The Court of Appeals didn't address the negligence per se issue because it didn't have to, because it had agreed with us and affirmed on the basis of the premises liability theory that Mr. Trentham proposed. The trial court rejected the negligence per se argument because it said, well, the code that was adopted by the municipality was not mandatory. Well, that was mistaken. Indeed, MAA doesn't even try to defend it on appeal. MAA argues other points, which, as we note in our subsequent brief in this court, MAA didn't raise below. So they're new on appeal. But the bottom line is that if the court were to disagree with Mr. Trentham on his premises liability theory, we would ask that the court then remand to the Court of Appeals and direct that court in the first instance to address the negligence per se issue. Because clearly there was a mistake by the trial court. Nobody is defending the trial court's analysis. And so we think at the very least, Mr. Trentham should have an opportunity for affirmance on that alternative basis. And if there are no other questions from the court, I'll thank the court for its time and again ask that the court affirm.
Thank you for your good argument. Your rebuttal, Mr. Parsley.
Mr. Parsley, as you approach here, I want us to a couple of things. Number
Yes.
one is to ask for a clarification, slight clarification, then a more basic question for you
Yes.
that I honestly didn't get to when you were up here before. Clarification is you seem to be distinguishing at one point between common areas and the bridge. In fact, isn't the bridge a part of the common areas?
Oh, that's precisely my point, is the policy was to clean the common areas.
But that
And
includes the
and
bridges.
that includes the bridge,
Yeah,
so they would
okay.
clean the bridge. But what the point is, it wasn't specifically focused on the bridge. It was all the common areas, including the bridge.
The more generalized and more question and more basic question is, and Mr. Fine alluded to this, what in a couple of sentences or a word is the standard that you're asking this court to adopt, particularly to the extent that you're asking us to at least partially overrule Blair?
Okay, I'd love to answer that question, Your Honor. First, I want to clarify, be very clear about our position. If you look at page 52 and 53 of our opening brief, we say the court may wish to base constructive knowledge on prior conditions, even in the absence of an accident. Okay? Courts applying Blair have done that. Here's our point. Blair says, okay, if there's a pattern of conduct, a continuing condition, recurring incidents, there can be constructive knowledge. That necessarily presumes there's some similarity between these past events and the current situation. If they're dissimilar, how can that put someone on notice legitimately, right? Okay, John Gerber, line of authority, is an evidentiary line of authority. What did it do? How do you establish constructive knowledge a second way? And it said, well, if you have prior accidents that are substantially similar and there's enough of them, you should be on notice. That's exactly what Blair wants to accomplish. It just doesn't say how to do it. What our position is that, the court could leave Blair as is, not change a word of Blair, and say the prior events that you look at need to be substantially similar to the current situation to be relevant, to help the trier of fact, right? That's what John Gerber does, and that's what is missing from Blair. If you put the two together, it makes Blair workable, right?
Mr. Parsley,
Yes.
how do you understand that final category that Blair mentions, the general or continuing condition language?
A general condition is quite puzzling to me, you're right. The only thing I could think it means is it's a condition that's everywhere on a property. But other than that, it's a very vague language. Very, very vague language.
What part of Blair, you say in your brief that You know, and Blair, of course, makes this clear that it is, you know, rejecting at least some of the cases that had established this method of operation test.
Right.
But other parts of that method of operation jurisprudence were kind of merged into this standard that was announced in Blair. What parts of the test do you understand to be coming from that method of
Pattern
operation?
of conduct.
Okay.
That's a mode of operation, right? A pattern of conduct is the same as a mode of operation, which Blair imported from these mode of operation cases, right? And mode of operation depends on mere foreseeability. It says you choose to operate self-service supermarkets. You know that customers drop slick things, so you should know. You're on notice of anything that could happen, right? That's foreseeability based. It approaches strict liability, and honestly, it was a policy judgment that the courts made that really should have been left to the legislature, right? I mean, basically, the courts are saying self-service supermarkets are bad, right? Because it didn't used to be that way. You had clerks that served you, right, in supermarkets. You went in and you handed the clerk a list, and the clerk went and got everything, poured it out, measured it, whatever, boxed it up, and gave it to you. The first self-service supermarket, 1916, opened in Memphis, and now products are packaged, customers shop for themselves, and they spill things, right? And so the mode of operation says, well, that mode of operation is bad as a matter of public policy, so we're going to impose effectively strict liability.
Why isn't it the case here that the pattern of conduct is the leaving common areas, including bridges, untreated, unwashed?
How do you know what you need to treat for unless you're on notice of a problem, right? You're basically saying, okay.
Well, are you advocating for no standard of care at all? Is that
no,
basically what you are saying?
We don't
How
get
does
to
that
the
translate into med-mal cases?
Your
and
Honor,
all
we
that?
don't get to the standard of care for remedying a problem unless there's first a duty.
But a premises owner, like everybody else, there has to be a standard of reasonable care, and all you're talking about is articulating what that is.
It's a standard of care for reasonable inspection, not maintenance. Pressure washing is maintenance. It has nothing to do with trying to discover a problem. Okay, this was invisible algae. So assume it's algae. How was Mid-America supposed to know it was there?
But isn't that the whole purpose of pressure washing? You don't do pressure washing just for specific instances to address a specific problem. Pressure washing is to address the whole problem.
Right,
solve
and if
everything.
the court says, as a matter of law, if you have wooden walkways outside, you must pressure wash them. Is that what the court's holding is going to be?
Well, that's a question that we'll answer.
I look forward to getting your answer.
But isn't that the same question for your client?
What facts put Mid-America on notice that there was algae on the bridge? It was invisible. I mean, you talk about superior knowledge. Mr. Trentham crossed the bridge hundreds of times, including each of the 4 days, most likely before he fell. Who had superior knowledge? It was invisible. How are they supposed to know it's there? The other thing is, you could pressure wash once a year. Their experts said, well, algae could grow in as few as 3 months. Okay, so pressure washing once a year wouldn't fix it. What would fix it is the as needed, right? Your pressure wash is needed. When do you pressure wash as needed? When you have done a reasonable inspection and discovered a problem that needs to be remedied, which is exactly what Mid-America regularly did with regular inspections. I think adopting the appellee's position is going to effectively impose strict liability on owners based on just pure foreseeability.
Thank you, lawyers, for your excellent arguments. The court appreciates your hard work, your great efforts to answer our many questions. That completes our argument for today, Mr. Hebner.
All right.